said, if you have a question, you can unmute yourself, but we need to try to take care of all the background noise and sound because this is being recorded. Well, I want to welcome you to the second session of this. We are saving it on YouTube, our YouTube channel, so you can always access it later. I'm wearing my Daytona Beach colors here. It's beautiful, and I'm going to go outside after we finish this. I want to go over the standard form changes that took effect April 1st. Everybody should have received a link to download them. The first form we're going to talk about is the optional listing information sheet. And this new form was designed so that buyer agents would have the answers that are necessary to fill out a contract properly before submitting the offer to you. You've heard me over the years say, please call and get two pieces of information definitely, and that would be what goes in paragraph 6 for communicating to the owner, and what is the answer to paragraph 14. And this form takes care of it. So if you use this form, K1385, and you prepare this and download it onto your listing, then it should have all the information that people need to make sure that they can fill out a proper contract without having to go back and forth with a bunch of counters for stuff that was left out. So if you take a look at the information for making an initial offer, first thing to note is at the very top of the form, it does not constitute a disclosure or offer and shall not become part of any residential sales contract. The information is provided for the sole purpose of assisting cooperating agents in preparing offers. Seller makes no representations or warranties regarding the accuracy of the information contained in this information sheet. This is something that is strictly put together by the listing agent. It should never be attached to or made part of the contract. It's just for informational purposes only. So sellers' names, that should be the way it's listed on the deed in the tax records. Preferred delivery, mailing address, fax, or email. And if you were to look at paragraph 6 of the contract, it says, in order for us to have delivery, it has to go to the seller at their preferred address, if email or whatever. If that blank is left blank, then it would go to the property being sold. So it's imperative that you give that information to the buyer's agent. FIRPTA, that's the Foreign Person Investment in Real Estate Property Tax Act. Paragraph 14 of your contract, that cannot be left blank. Okay. What you need to make sure that that is answered. They've changed paragraph 14 in our contract. There is no longer an addendum for FIRPTA, but what the buyer needs to be aware of, and the seller, is that there's 15% tax due on the sales price, not the profit, on the sales price. It must be withheld at settlement, and ultimately the buyer is responsible for that. So FIRPTA is definitely one we definitely have to have the answer to. The property information, tax map ID, most of this stuff would be filled in for you by Bright once you have it, but make sure you get it correct. I want to talk about parking spaces in the property information. One of the things that agents now have to be careful of, is this a limited common element, or do they own it by deed, or is it assigned? The old condos, you actually had a deed for your condo and a deed for your parking place. The newer condos, they're limited common elements. So the documents give you the right to occupy that space, but you never own it. So you cannot sell it. But some people go ahead and draft up a deed and sell that limited common element, which they can't do, but it wouldn't show up in the title search unless people are doing the expensive title search, because it would not be in that chain of liability. So definitely ask when you list the property, is it limited common element? Do you own it by deed, etc.? Most of that other stuff is pretty self-explanatory. And then there's the property subject to the condominium association, co-op, or POA, who that company, the association name is, phone numbers, lead-based paint. Remember, any property built before 1978 requires the lead-based paint addendum and or disclosure and an addendum and the booklet being presented to people. Utility information, make sure you definitely check all that. Once again, self-explanatory. The conveyances on the second page of this new form lines up with your contract, and there should never be a blank. It's either yes, no, and if it's more than one of them, the number. If it's not in there, then it's no, but don't leave a blank. Just don't check ones that just say yes. The fuel tanks, leased or owned. We had a case along this line this year where they checked they owned it, and it was leased, and the buyer found out it was leased after they settled in, threatening a big lawsuit, etc., even though the seller made an honest mistake and was willing to pay for buying the lease up and making it their own ownership. So be careful, double check everything. Listing broker information is required by the government now, so that people know where to go to find whoever messed up. So you have to have the listing broker's name and address, phone number, license number, agent, email, ID, etc. That is all required by the federal government. Other information, seller preferred settlement timing. When would they like to settle? Request post-settlement occupancy, yes or no? If they say yes, then probably going to use the addendum, which is probably a kiss of death, probably the worst thing anybody ever gets involved in. Other settlement preferences and requests. They can prefer that you use their title company. They cannot insist as an owner. I just had an email about this one 2 days ago. The seller's agent said, we're going to void the contract if you do not agree to use our attorney. That is strictly against the law. And the damages for that is 2.5 times the buyer's title insurance if you refuse to sell them the house because they won't use your title company. You can say we prefer, we can request, but you can't say must use our attorney. Seller preferred septic inspectors. You can have preferred inspectors. As a buyer, I'm probably not going to want to use who the seller wants. I'm probably going to want to use who I want. And then other, whatever you want to add in there. If there's any questions, I'll answer them, or at the end, I'll unmute everybody, and then we can do them at that point. The second form, buyer's acknowledgement of potential adverse consequences. Once again, this form is not part of the sales contract. It's for discussion and disclosure purposes only. I've used a form that I developed years ago that says, above the objection of my buyer's agent, I have decided to remove the following clauses from my sales contract to be competitive in the marketplace. This form has been around since 2005. It had never been updated since 2005, and this is an update to that form. But they are acknowledging potential adverse consequences. That's a little different than with COVID-19 addendum, which we'll take a look at because someone wanted to revisit it. In submitting an offer, certain contract provisions may be waived or not utilized, some of which are referenced below. Buyer's decision regarding these and other contract terms may lead to potentially adverse consequences. Broker can counsel on real estate matters, but buyer is advised to seek legal counsel or other appropriate professional advice regarding such potentially adverse consequences. Anytime anybody pulls anything out of the contract, it's going to have adverse consequences. We're seeing this quite in all these multiple contract presentations where they're pulling out the appraisal. And I don't know if you've watched what's going on lately with appraisals, but a lot of appraisals are coming in quite low because the appraisers are saying with this COVID-19, prices might go down, and they're reflecting that. So be very careful how they remove that contingency for appraisal. Also for financing, a lot of the loans are ending up being rejected. Were approved and now are in a position where income going down, et cetera, and people no longer qualify. So we have to be very careful with those. It goes on to say, despite the risk of potentially adverse consequences, the buyer elects to submit offers and ultimately ratify a purchase agreement for the property without the following, and they check each one they want to pull out. Notice with an appraisal contingency, FHA and VA and USDA does not allow the buyer to waive the appraisal. FHA says if the property doesn't appraise, the purchaser has the right to get out, period. VA is not going to let a veteran buy a property where it doesn't appraise. Any home inspection contingency, there is another option. If we looked at the home inspection contingency form, there is a choice 1 and 2 now. Under 2, the purchaser could purchase the property with a home inspection without the right to ask for anything to be done, but they could still void their contract. So there is another option for home inspection. We'll talk about that contingency another day. The next form, the listing agreement amendment form. I want to talk about, before we actually look at that form, if you went to Bright and you look at status definitions for listings, there's different definitions. One, active properties currently subject to a listing contract and reported to Bright MLS, which the seller has directed you to set appointments for showings, seek agreements, etc. Active under contract properties, and there's a written offer that's been accepted, but the seller agrees to continue to show the property and accept backup offers. That's what active under contract means. Subcategories would be kick-out, third-party approval, attorney review, but you need to get these into the right category. Closed is closed pretty much, you know what that is, about a closing, and you need to get that changed in the system. Expired listings in which the date for listing is actually passed, there is no longer a listing. Then one that's causing a lot of confusion and problems is withdrawn. And withdrawn, you actually, they're still listing. You cannot call to try to list that property. The owner still has a listing with their agent. They've just told them to take it out of the system, which you might see a lot of withdrawals right now because people don't want people coming into their homes because they're afraid of this virus. Temporarily off the market, sellers requested participant to suspend the marketing, not set any appointments, so temporarily off. Pending is the agreement of sales in effect, and there are no real contingencies. But here's the one that you need to understand. Canceled. Properties in which the listing contract has been terminated prior to the expiration date. They have actually ended it. So the ones you can contact, expired and canceled, not withdrawn or any of these other categories. So if you're trying to get listings from people that no longer seem to be listed, make sure you get this one right. The other one is coming soon. I had a question about coming soon. Coming soon properties currently subject to a listing contract and reported to Bright MLS, where the seller said, I don't want it marketed yet. You want to put a coming soon sign on the property. If you have a coming soon sign on a property, you must have a signed listing agreement, and that must be in the system within 24 hours after you put that sign up. And it cannot be shown, etc. during that time period. No market. So you can market it, but no showings, no contracts. Well, I had the question, it was incoming soon. And then they said, well, we already received a contract when it was not, when it was incoming soon. Can they do that? Yes. An owner can accept a contract anytime they want. So if the contract is presented to them and the person's never seen the property, they could do that. And we're starting to see quite a few of those now. But you better be careful with that coming soon status. Has to be in the system within 3 days or within 24 hours of any kind of advertising, sign in the yard, anything on the internet. Because the question I just got was, I want to put it in the coming soon under in one of the sites. And I said, well, unfortunately, you cannot do that because of the coming soon policy that NAR has come out with. And it's called the Clear Cooperation Policy. Now, what if an owner doesn't want their property in MLS? Well, you could actually take what we call a private exclusive. What does private exclusive mean? That means you can tell other people in your firm, but you can't put any advertising out about it. So your firm could show it. Why would an owner want to do that? Well, it might be a high profile person, or it might be a divorce. I want to go to the listing agreement itself. You don't have it, but paragraph 10 of the listing agreement, if you look at it, it says seller authorizes, does not authorize the broker to market the property via multiple listing. If seller authorizes broker to market the property, you have to have it into the system. And it says this right in here: broker shall enter listing information in MLS within 3 business days of commencement of the listing period or on or before that date. In either event, broker shall enter the listing information in MLS within 1 business day of public marketing of property. 1 business day, according to NAR's definition, is not Saturday, Sunday, or a holiday. Public marketing includes, but is not limited to, displaying flyers in windows, yard signs, digital marketing, etc. So your seller has agreed that it has to go in the system, okay? Or you can do the private exclusive, which is a choice. And I'm going to do a session on that maybe next week, okay? So let's take a look at the new form that we have, listing agreement amendment. They did away with the listing withdrawal form. And the reason they did that is because of the change of definitions in the computer system under Bright. And that's why I encourage you to go and take a look at those categories. But listing agreement amendment is made on, you choose one: exclusive right to sell, exclusive agency, exclusive right to sell on improved land, etc. The purpose of this amendment is to modify certain terms of the listing agreement as specified below. You'll note that it does not modify or change the listing agreement in any other respect, and all other terms will remain in full force and effect. So they could choose to, if you want to lower the price or raise the price, you want to extend the listing period, or when it should be entered in MLS, or temporarily off the market. We're seeing a lot of temporarily off the markets. Quite frankly, unless I was desperate to sell my house, I'm not sure that I'd want a bunch of people coming through my home right now. I got the question, can we require them to wear masks and gloves and stuff like that? Yes, as long as you're doing it of everyone. The agent said, if you're going to enter the property, you have to call me. Your buyer has to wear mask and gloves, and I will meet you at the property. I will stand outside to make sure you guys adhere. And the reason being is I'm going to sterilize the property. I'm going to clean everything before you come in, and I'm going to go back in and clean it when you leave. That's perfectly fine, okay? Withdrawn from the MLS. Remember, there's still a listing. It's just now become an office exclusive. Unless that cancellation box is checked and signed by all parties and the broker, that withdrawn is still the listing of that broker. You can't interfere with my agency relationship. That would be a problem under Article 16 of the Code of Ethics. Now, the COVID-19 form. Before I go into that, is there any questions? I'm going to unmute for a second to see if there's any questions.
Okay, so the deal was supposed to, my listing was supposed to close yesterday, but for they used the COVID-19 to get out of the contract because apparently the buyer's overseas, and it was, you know, so my thing is on the listing now, the seller, can I just withdraw it and the seller can rent it out, because that's what she's thinking.
So they did not settle. Did the seller okay with the fact that they're not settling?
No. She's going to take an attorney and she's going to go after the EMD for $10,000. She's already contacted an attorney.
Okay, but they did not settle yesterday.
No, she settled her portion. I mean, she signed the documents. So she's compliant by the contract as being time of the essence.
Okay, so yesterday it was a settlement,
right,
according to the contract.
Right.
Well, as of midnight last night, there's no longer a contract. So you could take that listing out and put a new listing in, but she'd have to sign a listing.
Right. So we can withdraw it basically then, right?
Well, it's not withdrawn. It just, you know, I would still get her to sign something, you know, saying cancel that listing now.
Okay.
Okay. But technically, once they did not settle, there is no longer a contract, and your person's entitled to get a lawyer to do it. But you could reissue, you could kill the listing and put a new one in, probably. Yeah.
Okay. But she doesn't want to do it. I mean, she's basically going to rent it to a friend of hers, so I can just go and withdraw it. That's what I'm saying. Okay.
Yeah. Get her to sign something to that effect, canceling the listing. Okay.
I'll mute myself now.
Well, let me talk about the COVID-19 form. Okay. And some of the forms to do with the lease. Somebody wanted me to go back over COVID-19. I'm going to do it real quickly here. The COVID-19 addendum form. It talks about unforeseeable events. An unforeseeable event, the COVID-19 is no longer an unforeseeable event. Prior to contracts were prior to this happening, you probably could go back under the impossible to settle part of common law and maybe get out of a contract. But if it's had this addendum, you could go back and use this addendum on contracts already existing if both parties want to do it. But definitely use this with your new contracts with your buyer clients, because we have no clue where this is going. I was just on another session this morning with NVAR, where Doug Ingram, my lender, was talking about all the challenges to lending now. We know there's going to be some delays. So this form will protect your buyer in the event of these things. Now, the one claiming COVID-19 yesterday, you know, they may very well have a case against them, and they do need to talk to the attorneys. I agree with that. So unforeseeable event means any event or circumstance beyond a party's reasonable control. So to not use this form now, once we know of all these consequences, I think might be a problem for the buyer. Make sure you get this in there. The buyer and or seller shall not be in default or incur any liability to the other party for any losses or damages of any nature for any failure to or delay in the performance of their obligations under this contract arising out of or caused by. So this does not allow anybody to void a contract. Okay. What it says is if we can't settle for these reasons, once we hit settlement date, we are not in default. Okay. The contract no longer exists. We're not in default. Everybody will sign a release of the contract. Everybody will agree to the money going back to the buyer. So this contract, this does not give either party a right to void anything. if you use paragraphs 3 and 4 of this addendum, that is for contracts that you need to change current contracts because general settlement date needs to be changed or specific extensions. Or you can use it with a new one if you need to extend. So this COVID-19 form, we recorded last week's session. If you check with Johanna or Nestor, they can probably show you where it is. If we need to go over it again, I'll do it next week. I do want to cover new forms that came out literally yesterday at about 3 in the afternoon from NVAR. And it's request due to economic hardship. This deals with leases, okay? And I believe they got the form to you, Form K1387. This is a request submitted by a current tenant asking for a reduction in rent because of the COVID-19 has affected their income. So the tenant must complete the form in its entirety prior to landlord's consideration of request. Landlord is not obligated to accept the request, but this is the tenant's request shall not act as a waiver of any right or remedy of the landlord, and tenant remains responsible for paying all rent, including deferred rent under the lease. I think most landlords are probably going to be pretty reasonable about this if the tenant can prove the hardship. Right now, you couldn't evict anybody for non-payment of rent. It'd be pretty tough, and the government, lenders can't foreclose for at least 30 days. So if you have a tenant that's experiencing difficulty, they need to submit this form, requested dates of rent deferment, how long, what the payment will be during that time period, describe the basis for this request. Because I got this question 3 weeks ago. Do we just have to take their word for it that they can't pay the payment? No, they need to attach supporting documentation, proof of furlough, unemployment, amount of unemployment assistance, etc. So this form is for the request. One thing that Virginia also put a form out, their form 200, which we sent to you originally. You can use either one, but I sort of like NVAR's forms because it matches up with our leases. But there's a rent alteration agreement by VAR, similar, but their request form is a lot simpler. Now, one thing NVAR did to help us out, notice regarding requests due to economic hardship. So this is for a landlord to give an answer back. They can deny, request denied, would pose an undue financial hardship on the landlord or unable to verify the information. Request approved, if you approve it, etc. I'm not going to sit here and read the forms to you. I just wanted you to know that if you are dealing with any kind of rental properties or managing your own properties, then these are the forms put out to help you with the circumstances we're experiencing today. Any questions?
May I ask a clarification question on the COVID-19 form, since I don't hear any questions on this?
Sure.
I just want to be clear that if writing a new contract today and representing obviously the buyer, that the COVID-19 form should be included as part of the package.
Absolutely. Absolutely. Because that would protect them if you need any run into any problems with your loan or appraisals, because a lot of appraisers are not going out and doing appraisals now because they don't want to take a chance, or home inspections, etc. So this would definitely protect your client. You don't want them to be in default. See, because we have time is of the essence in our sales contract. And time is of the essence says if your buyer fails to settle for any reason, other than a default by the seller, which would mean the seller pretty much refused to settle, then your buyer would be in default as of midnight on the date of the contract of settlement. This will allow them, if for some reason they couldn't settle, that they're not in default, that, everybody's acknowledging that it's not a default because of the situation. They no longer will get the house, but they won't lose their deposit. So definitely use this with all new contracts. To go back and get a seller to agree to this now, they might, but definitely use it with the new ones.
Thank you very much.
Hey, Larry, a follow-up on that. You said that like for the lease, they have to give proof that they have been furloughed and all that. In this case,
Yes.
COVID-19, does the buyer have to give a reason or say, hey, I want to get out of contract, even though it's a cash deal? They said that.
No, if it's a cash deal, there's no getting out. Okay, unless they use that addendum form and they couldn't get the appraisals or that type of stuff.
No.
But then you would use 3 and 4 for specific extensions. And look, you only use it for one. So under paragraph 4, the COVID-19 addendum, if you're going to do a specific extension for radon, then you would put up in the right-hand column number 1. You don't do multiple ones on this. Each one would be a specific extension. So if you needed to extend deadline for radon financing, each one would be a different addendum.
Okay, so I'm just trying to kind of pick your brain because the broker on the other side is saying, oh, first they said they cannot travel, which is not true, from overseas because it's an overseas buyer with a cash deal. And now they're saying, oh, we don't have to give you a reason because he cannot access his funds. I know the banking system is not closed internationally, so.
Well, it's not, but paragraph, time is of the essence says if they fail, or actually paragraph 28 says if they fail to settle for any reason other than a default by the seller. And there was no unforeseeable event clause in our contract. And that's what people don't understand. There is nothing in our basic contract about unforeseeable events. That's why they came up with this addendum, because we haven't had anything like this before. So that's the idea behind the COVID addendum. There is a principal law that says a possibility to settle for unforeseeable events, but they'd have to go to court with an attorney and have that attorney try to prove that principle, which would be pretty difficult in a cash deal. So, I mean, that might be their only defense.
So technically COVID-19, like you said initially, is not, if it's signed between this time frame last couple of weeks, it is really not an unforeseeable event then, right?
No, no. I mean, because there was no definition of unforeseeable event in our contract. That's why they had to come up with this form for what an unforeseeable event is. And remember, when there's quotation marks around words, remember that sets a definition. So if you look at the COVID-19 addendum, number 1, unforeseeable event is in quotation marks, and now it gives us a definition because it wasn't in our contract before. So like I say, they could probably go back under that principal law and try to use that as their defense if they get an attorney. But, it wasn't addressed in our contract before. And that's why you need it now with all new contracts, because we do have the definition of unforeseeable event in this addendum.
Okay. And as long as the seller doesn't sign the release, the title company is going to hold on to the money till one of the parties sues the other party for the EMD.
Yeah. Yeah.
Thank you so much.
That's where it's nice that the company's not holding the deposit. That's why we prefer that you have a title company hold it.
Right, I got you.
Hey, Larry, quick question about the COVID addendum. So are sellers required to sign this addendum even before or now?
No. It's an
addendum. I feel like sellers are put at a disadvantage with this addendum because whether buyers or their agents understand it or not, they may use it incorrectly. And the only way to actually figure it out is by going to court. I mean, who actually wants to go to court?
Yes, that's why I said if I'm representing a buyer, I want the form.
Yeah, so if you represent a seller, then you would try to not get the seller to sign it then.
Well, I'm not sure that I would recommend they not sell it, sign it. I think I'd go more along the line that how marketable is your property right now? So if it's very marketable, you might not want to sign it. But if it isn't, and there's not a whole lot of buyers out there looking at your property, I'm going to go over next week. I want to go over some stats from NAR and from VAR. They're saying about 50%, NAR is saying 58% of the buyers now are on the fence. They're not going out to look. They put it on hold. So if you lose 58% of your purchasers, now we're in a unique position here because of the lack of inventory still. But, you know, I was looking to buy a condo myself for, you know, and I was only seeing about 15 listings. I pulled it yesterday and there's 95 listings that meet my criteria right now. So as a buyer, if I'm seeing 19 where there was only 5 before, what am I thinking? I'm thinking I'm going to get a what? I'm going to negotiate price. So it depends on how marketable your property is. And we're going to discuss that next session.
All right. Thanks, Larry.
But these are addendums. So, you know, an owner can counter back and say, no, I don't want this addendum. Absolutely. Any other questions? Well, even though I'm in Daytona Beach, you know, toughing this out at the beach and whatever, because we can still go to the beach and we can still go to our pool and everything. I'm still working. So if you have questions, contact the managers and they'll contact me, etc. So I'm still actively working.
Larry.
Yes.
I have about 3 listings, which is I'm afraid to put them in the market because of this virus. If it's that this addendum comes and I don't sign it, it's not anything against the law, right?
No. They don't have to agree to COVID-19 addendum. No, the seller does not have to agree to it.
All right. Thank you so much.
It's like any other addendum, home inspection or whatever. It can always be what? Countered or just said no. You know, we'll accept your contract, but not with this. You know, the biggest problem right now is I think more with leases, because people enter these leases and they are getting laid off and they can't afford it, and so you may get that request with these new forms. So just take some time, read through them, be familiar with them.
With a listing, I don't have to put any extra addendum for the seller to sign or anything. It's just the same as before, right?
Correct. I would use this new information for making an offer form that's optional. I would definitely, I mean, to get a contract that's properly filled out, if you supply all this information to the buyer's agent, they should be able to copy it into their contract and give us a decent contract, you know?
So what is the name of that form?
It's information for making an offer. It's one of the forms we went over. Has all the information about the seller, the property, utilities. You fill all that out, you scan it, upload it into the multiple listing, into the Bright, and the buyer's agent has all the information they need to properly fill out a contract. I think that's a winner. I like that form.
Thank you so much.
You're welcome. Any other questions?
Larry, this is Venkat. Where is that form that you just mentioned, like information?
They scanned the forms and downloaded them for everybody to download to print out.
Okay.
So you should, if not, you can go to NVAR site, and it's form K1385.
1385. Okay. Thank you, Larry.
Okay. But all these forms are uploaded now. These went into effect April 1st.
Okay.
But I love that. I'm sorry, go ahead.
This is Ingrid. I have a question on the COVID-19. Do you fill out paragraph 4 and how many days, or do you wait if you can't meet the deadlines and then ask for extensions?
If that's where you're asking for specific extensions, so you wouldn't do that until you need it.
And then you would use that form, or
Yes,
would you just use another addendum extending?
I would use the COVID-19 addendum, or you could use that a different one. But did they agree to this form up front?
No, I'm just asking what if
Yeah.
when we do that form we would not fill out paragraph 4 unless it happened.
Right. 3 and 4 are for existing contracts or when you need it.
Okay, thank you.
Okay. Now you can do the number 3 is just general settlement date and deadline extensions. So that's for settlement, but if you need to only extend one specific one, then you would use paragraph 4 when you need it.
Okay,
Hey,
thank you.
Larry, just, and pardon my ignorance, I know I have a sheet where it says pending, active under contract initially when they started all this with the new Bright, but where can I see it online? I mean, all these different.
Go to Bright, log into Bright, and go to they have a section that explains all the rules and regulations of Bright, the use of Bright, and it's in that document.
Rules and regulations. Okay.
You would, are you on Bright site?
Yes, I just logged in Bright, and it says search client, my listings, finance, market research.
All the way over. I think it was all the way over to the far right at the top.
Okay.
For Bright. I downloaded it yesterday.
Okay, I'll look at it. I don't want to waste the group's time, but carry on.
Yeah, but you can find either that or just call them. They'll tell you where. But
Okay,
they have a section on how to for where you change your settings and all that kind of stuff in that part there. Bright rules and regulations, and you can print all those out.
Okay.
Larry, what are the regulations that we're referring here?
We're referencing Bright MLS definitions for active, canceled, withdrawn. All those definitions are defined on Bright's site.
Okay.
I read them. I read them earlier.
Yeah, it's under Larry's under policies, and then it's like a PDF, 41 pages.
Yeah, but it's in that. Yeah, I think it was pages 8, 9, and 10 or so of that policy manual.
Yep.
Okay. Thank you, Larry.
But you really need to know what you're changing in a computer to not have a problem, especially if you're going to call looking for a listing or whether or not you could contact an owner. And also remember, do not call list. Fits into that too. But you don't want another agent saying you're interfering with their listing because it was withdrawn. Because our old form, the old form we had withdrawn meant what they call canceled now in Bright. So they just changed our form to reflect Bright's terms. Any other questions?
Yes. When you
Okay.
mark withdrawn, how long? It just says effective. How long can you withdraw?
They can withdraw until it can stay withdrawn until the end of your listing.
Okay.
Hi, Larry. This is Maribel. How are you doing?
Yes, Maribel. How are you? I'm fine.
Yeah, okay. Good to hear. Okay, I have a question about COVID-19. If I have a buyer and the seller doesn't accept the addendum, I know the lender are checking the word, they have the verification on employer until the day of the settlement. If something changed, we have the financial contingency, yeah, to go out.
Unless you've removed your financing contingency.
Yeah, but my client, maybe if they have different employee or they lost time, they have the financial contingent until day of the settlement. I put the same day, yeah?
Well, if you said you had 21 days in the financing contingency and you go past that, well, and the owner has not sent a notice over of not receiving the written commitment. If the owner hasn't sent that notice over, then the contingency continues up through settlement up to midnight on the day of settlement. So if they got turned down for their loan and you've never received that notice from the seller that they, given you 3 days to either void your contract or move forward, then yeah, they could still get turned down and be out of the contract.
Okay, perfect.
That's why I never send over anything until we're forced to, for the financing contingency as a buyer's agent, because
Okay.
it continues up to, and we'll maybe one day we'll go over that form again too. We're going to do these weekly, by what I understand.
Okay, perfect. Thank you, Larry.
Okay. Any other questions?
And if you have a question, Larry, you said we can email it to you or call you? Or...
Email it to Jocelyn or Johanna, and then it can get it to me so I can get a list together and know what people want to talk about.
Okay. Thank you.
Okay, or email me. I don't care. BrokerLarry1@fairfaxrealty.com. What you want to talk about.
All right. Thank you.
Okay. All right. Well, everybody have a nice day.